And Nick Maruchek from MKI Legal joins us. Good morning, mate.
Good morning, Gary.
133882 if you'd like to speak to Nick. Just stand by there, John, because I do want to ask Nick his reaction to the discussion I just had about this right to disconnect. It comes into effect on August the 26th. It will be LAW law. But I'm a little bit because I kind of just go through my life trying to apply common sense to everything I do, and that might be work, home, play, whatever, okay? So I'm sorry, I don't get it. How is this going to work if, Nick, I'm going for a job interview and the employer says to me, Gary, we really want to have you on board. Just one more thing. There's now a new law. It's called the right to disconnect. Will you exercise that if you come to work for us?
So, Gary, they can't ask you that question in that form, that directly, because the right to disconnect is a workplace right. So that means it's illegal for the employer to retaliate against you if you exercise that right.
They're not going to retaliate, though.
Right?
They're not going to retaliate. They want to know whether that's your mindset.
If they ask in that way, a lawyer will jump on it and get them.
Really?
But there's a way they can ask you, right? The way they should ask if you're hiring is you talk about the job and you talk about the duties in terms of answering phone calls, answering emails after hours. And they ask you, and they say it's part of the job to answer calls, answer emails after hours. And the employer might even be might allocate a portion of the salary to dealing with after hours contact.
Right.
So you may not get paid more, but in the contract, we're definitely going to see new contracts. I'm expecting this to say that this is your a part of your salary has been allocated to dealing with these after hours, because if the employer and the employee get into an argy-bargy, they can't agree. And I agree with you. This is common sense. I'm hoping that a lot of things can be resolved. Good communication, common sense. But if they can't resolve it, the Fair Work Commission will be the arbiter, right? They will make a decision on whether the employee turning their phone off is unreasonable or not. And the things that take into account is that the role and whether there's a payment for the additional out-of-hours work, the level of disruption, and the personal circumstances. So that employment contract and the job description is going to be really important when the Fair Work Commission makes a decision.
Do you agree, though, with this scenario, that if I am provided a phone by my employer, and that's not necessarily just, I mean, I can use that phone to Facebook search or whatever it might be. I might be trying to find something on Facebook, and I could be doing that during work hours. That if that is the case, how could I seriously argue about my right to disconnect from the phone and the connections that have been provided to me by my employer?
Well, it all depends on each individual case, right? So if you're in a sales role and there's an expectation that you call back clients after hours, and you were told up front that's the expectation of the role, then it might be harder for you to argue that, right? It all depends on this word reasonable. Is it unreasonable to turn your phone off, right? And in some cases, it might be unreasonable, and in other cases, it might be reasonable. So the law has left this grey area.
I reckon lawyers are going to be busy.
Oh,
I reckon there's going to be plenty of work in this one, Nick. Don't worry about that.
I hope common sense prevails and we don't.
Exactly, but it never does. And you know that, okay, everything might be tickety-boo at the point that you're starting to work for someone, and then you've got into the actual workplace and you go, hang about, there's so many calls I'm having to do. I'm sorry, but I'm going to exercise my right to disconnect, and then it will get ugly. Let's just go to John, though. He's got a workplace issue as well. Hey, mate, how can we help?
Oh, good morning, Nick and Gary. Just a query. If an employer stands down an employee for whatever reason, and the employer asks the employee to go to a neurologist and have a test, and then we'll think about perhaps re-employing you, are they allowed to do that?
Okay, so when they stand you down, is this employee a full-time, part-time, or casual?
Casual.
Okay. So it's illegal to discriminate against a medical condition, but there is a catch here. The employer needs to be convinced that the employee is medically fit to do the job. So what often happens is that an employer will send the employee to a consultant, a doctor, to get a test done. So the question comes down to whether it's reasonable for the employer to make you do that medical test. a lot of the time it can be reasonable. If that neurology, if there is some sort of issues that are coming up that's affecting the employee's ability to do their job, and they can't do the key inherent requirements, then the employer potentially is within their right to get a medical assessment done and then make a decision whether the employee is fit for the job or not. If they're not fit, that can lead to dismissal. But before they dismiss, they have to do one extra thing. They have to take steps to make reasonable adjustments to the employee's position, which means that, is there something else you can do in the workplace despite your medical condition? So these are the discrimination laws, and disability discrimination is the word disability is very wide. It can cover any medical condition. So it has to be done very carefully, because if you get it wrong, then you're sued for discrimination. And as an employee, you can always request those medical reports, because a lot of time they don't give it to you, and then you have to make an application on the Privacy Act to get them. But always get them and read them, because if you don't read them, sometimes the employer might, read the report and it says you're fit, and I've seen some stuff happen where they just get rid of you anyway.
Or they may interpret some way that you wouldn't interpret it in terms of your employer. Does that help, John, with your situation?
Yeah. I think that answers everything. Thanks, Gary.
All right.
Yeah.
No. Good luck with it all. Bruce is there. G'day, Bruce.
Yeah, g'day, gents. Just apologies if I don't articulate this adequately, but a couple of things. You were saying there that contracts where employers will now allocate a certain portion of an employee's salary to answering phone calls after hours. Does that, and it won't necessarily mean that we get paid more money, does that mean that instead of being expected to work the 8-hour day, that we're going to work 7-hour days, for example, and allocate an hour to answering phone calls after hours, or are they still expecting us to do unpaid overtime? And secondly, if contracts are going to be rewritten, what happens to existing employees with their existing contracts? They can't tamper with those, surely.
Really great points there, Bruce. I think that, first of all, existing contracts, you need to get an agreement from both sides to change the contract. So if you've got an existing contract, they want to tamper with it, stand your ground and say, look, I don't consent to this new agreement. And so that's one thing to do there. And
I was going to ask you, though, that question about that hour.
That hour.
Might be the hour.
The hour, right? So this is where employers can do two things, right? They can decide, okay, they can be a little bit stingy and include it all and no extra pay, or they can allocate extra pay. If they're allocating extra pay, right, when the Fair Work Commission makes that determination, that's going to help a lot. But if there's no extra pay, then it's still, like, as long as the overall salary is above minimum wage, that'd still be considered. So it's just a little trick that employers might do to try and make it easier to argue. They don't have to pay you more. And also there's an expectation that full-time employees have to work the 38 hours plus reasonable overtime as well. And the other thing about this law is that it only applies when you're off the clock. So what an employer can do is also make you stay at work longer, right? Because when you're at work, and it's covered by reasonable overtime. So as long as that extra hours are reasonable, again, that word reasonable.
Could you stay back and finish this off, Gary?
That's it.
Do you mind, mate, if you just, would you be able to sort this out? Because we need it done today. We can't wait till tomorrow.
Yep, they do that. You're right, disconnect doesn't apply because it's not out of hours. So
I tell you, and we're going to go to a break, but I was looking at sort of the actual legislation. Several factors must be considered when determining whether an employee's refusal is unreasonable. This includes the reason for the contact, how the contact is made, and how disruptive it is to the employee. So, and I take it that it means if I'm out walking the dog. If I'm out walking the dog and I think, no, I'm out walking the dog, I don't want to talk now, whether the employee is compensated for the extra pay, of course, being available to be contacted to perform work within a specific period, working additional hours outside their ordinary hours of work. I don't know. Well, watch with interest, 133 882. You might have a question around this because Nick's the full bottle on it, because I reckon he knows there'll be a lot of people knocking on his door asking questions about where they stand. Nick Maruchak from MKI Legal will be back in a second. It's 17 minutes to 11. 133 882 is the number. Nick Maruchak from MKI Legal. I think the workplace could be the discussion for a little while to go yet. Let's take a call from Mark. Hello, Mark.
Yeah, hi Nick, hi Gary. Nick, there's something that's bugging me. My son is working, well, he's permanent part-time at the moment, but he's applying for jobs. He's well qualified to do these jobs. He's applying for jobs online to a lot of mining companies, but a lot of these companies seem to appear to me, this is bugging me, that they only put down female or Aboriginal applicants, and then if you don't put that in, you can't continue further on your application, doing it online. Is that discrimination? And he'll apply for sometimes up to 400 jobs a month. But is that discrimination?
Yeah, it could be. It could be racial discrimination. That's a pretty that could definitely be, you can discriminate against based on colour of your skin. The only defence a company will have is if they have some positive obligation under some law to hire Aboriginal people, so that if they have to get some sort of minimum standard, minimum numbers. But it definitely could be, because the colour of your skin should not be taken into account. There is some defence there if you're doing something specifically to assist with a marginalised group, and if there's a special program, a special thing in place that assists a marginalised group, that could be a defence to a claim. But generally speaking, overall, that could be discrimination.
Surely, though, Mark, I would have thought that in that job, if you can only go that so far in terms of your application, then that before you apply, that's a job that they're looking to fill with an Indigenous woman, don't you?
Yeah. So they would say that.
That's what I would have thought, yeah. Doesn't it just say that?
No, this is my son. When you apply for these jobs, because I'm not, correct me, I'm a bit, comes to computers, I'm not IT, but he is applying for a lot of jobs. He's qualified because he's done all these things online. He's even got a diploma in certain categories of that. He's applying for IT or whatever. But as soon as you get to that question, female,
okay.
it will not let you continue unless you put the female or the Aboriginal, whatever, into it, and you cannot go any further to apply for the job.
So you see a job, you don't necessarily know until you get to that certain point when you're going through the process that you're kind of going to hit a wall. They
ask you what gender you are. They ask you what race you are. Do they ask you that question? Because they
ask you whether you're female and whether you're Aboriginal. Is that right?
That's correct. That's correct. Yes.
I have a problem with that. If it's not a specific role, that's it's a key requirement. That will potentially be discriminatory.
Okay, Mark. Thanks for that.
Mark, I can give you a call and maybe give you a few pointers offline. But it is a sensitive issue. But companies. That's a very direct question. That should
be spelt. That should be like right there at the very front. Mm-hmm. We are seeking young Aboriginal women to work in our. They should just say it. And so therefore, you're not even going to go to that next point. But anyway, okay, all right. Well, we'll leave that one there. Will's there. G'day, Will.
Good morning.
Hello, Will.
Hey, good morning. I received text messages from my Eastern States employer out of hours. They're usually just info type text messages advising of changes of policy or things like that. But because of the time difference, 2 hours, and during daylight saving 3 hours, I'm receiving them as early as 4 o'clock in the morning. Now, I could just turn my phone off, but I can't for other reasons, a personal reason and also my work reason. What I want to know is, can I stop them from sending them during those hours, early hours in Western Australia?
Okay, great question. So just a quick point, these right to disconnect laws only apply if your business has more than 15 employees. Mm-hmm. If you're less than 15 employees, you're covered next year. So it's just an extra year to wait. So you can basically first ask your employer, stop sending the text messages. And then if you can't agree, there actually is a process where you can go to Fair Work and actually get an order to stop them from contacting you after hours, right? So you can go as that far to actually get a court order to stop them from contacting you during work hours. And, if all those factors line up, you could be successful. But first step is definitely ask them. And these right to disconnect laws is basically the employer has a choice, like your previous guest said. It's the employee's choice whether they respond or not. But if the contact is still happening, then you might go to Fair Work and say, I want a court order to stop this.
Because is it necessary that you get those text messages, Will?
Well, it's a big company. They've got a couple of hundred employees Australia-wide. and they just send them out. But of
Right,
course, they
right.
typical Eastern States companies, they think of the
Yeah.
Eastern States time zone, and
Yeah.
that's that.
Yeah, okay.
So,
Well,
4 o'clock in the morning.
yeah. They should be able to
Wait.
rectify that. If you say, I don't need to be on that text line,
Yeah.
don't send them to me. I mean, I don't know. But
I think
look,
ask them, and yeah, I know a simpler solution might be just, just put your phone on silent and don't answer and don't look at it till you start.
well, he's saying that he
the
needs
clock.
to have it on for
Yeah.
other personal reasons. But the other question, I suppose, maybe when he comes to renegotiate a new deal with them, he says, by the way, can you stop the 4 a.m. text messages? I don't need them.
Yeah, but just ask. It's a simple question. They should be able to fix
It's
it.
all part of the grey area, I reckon, is coming our way. Lucy's there. G'day, Lucy. You've got a question about a company car.
Yes, I got a question about company car. When we sign a contract, there is nothing in the contract saying that if you are involved in a car accident, you are responsible to pay access fee until it happened with one of our colleagues. And now the company asks him to pay the access fee.
Oh.
And it's nothing on the contract, so I don't know whether we have right to refuse to pay that or just to go ahead with it.
So so basically, what normally happens is if it's a company car, they gave you a company car to perform your duties. If the accident, was it the employee, was it their fault or someone else's fault?
No, it's their fault, yes.
Okay, they were at fault, but they were during working hours?
Yes, they have a client actually in the car because we are driving a disability car.
Right. Okay.
Yeah.
So I would probably, because it's a tricky question, but I would probably say to them, look, as an employee, I have the right to be indemnified, which means reimbursed for any expenses I suffer as a result of doing my job. An employer can't also force you to pay money to do your job. There are big restrictions in the law to force an employee to pay money in that respect. So I would push back a bit. I haven't come across this specific issue, but I'm happy to kind of have a look at it and give you a call, Lucy, and give you a few pointers. But I would push back because
it's not in the contract that should you be in a car accident, you will have to cover the excess on that damage.
And even if it's in the contract, an employer can't enforce such a term unless it's reasonable and for the employee's benefit.
Yeah.
So that there is laws in the Fair Work Act that says you can't force an employee to make a payment in order to do their job, right? Unless very strict criteria apply. So I reckon this one is potentially unlawful and you should push back on it.
You know what? I reckon I'll throw my two bolts. Should the person you're talking about, Lucy, be getting? And what do you think of this? Should they ask for the insurance policy that the company has in terms of that car? Because then you would see.
Yes, he asked for it.
Yeah, okay.
He asked for it, and then he was sent a form to fill up and put all his details, including his bank details, so they can deduct that access fee from his account.
No, yeah, I would push back on that. I would say, look, it's part of doing the job. There's a risk that an accident will happen as long as the guy wasn't or the girl wasn't drunk or on drugs or something.
Nothing like that, Lucy. Nothing in this instance where there's alcohol involved or anything.
No.
Yeah, and it's just foreseeable that an accident will happen. So I would push back, but happy to give you a call, Lucy, and just give you a few pointers. But I'd push back, and if so I'd push back on that.
I mean, the policy that the company would have would be probably a comprehensive car insurance policy to cover their workers.
Yep.
And they're going to be, it's not going to be sort of like one driver every day, the same vehicle.
Yeah.
It might change. And that their policy would just cover that, including the blimmin' excess.
Exactly.
All right, that seems a bit weird. It looks like they might be having a lend, Lucy. Thanks very much for that. Nick Maruchak, thank you very much. We'll continue the workplace debate later.
Thank you,
Another
Gary.
day. Nick Maruchak from MKI Legal there. It's 4 minutes to 11.